Imagine you're an immigrant, eager to contribute to the greatness of your new home, the United States. But there's a misconception that national interest waivers are only for the elite or the exceptionally talented. Is it true? Let's find out. Often people think that national interest waivers are the preserve of the elite, the exceptionally talented, or those in high-end professions. That's not entirely accurate. In reality, these waivers are accessible to anyone who can demonstrate that their work is of national interest. It's not about how many degrees you have or how many awards you've won. It's about the impact of your work on the US. Does it push the boundaries of science, drive economic growth, or improve the lives of Americans? If your work can make a substantial impact, then you are a potential candidate for a national interest waiver. Now that we've debunked this common misconception, let's dive into the 7 most frequently asked questions about national interest waivers. First off, what exactly is a national interest waiver? Well, it's a special provision within the immigration process of the United States. It allows certain individuals applying for a green card to bypass the labor certification process. Now, you might be wondering, why is this important? The labor certification process can be time-consuming and complex. It involves proving that there are no qualified US workers available to fill the position that the immigrant is being hired for. However, with a national interest waiver, this step can be waived if it's in the best interest of the United States. So, who benefits from this? Primarily, it's designed to attract immigrants who have exceptional abilities or whose work is considered significantly beneficial to the US. This includes individuals in fields such as science, arts, business, or education. So, a national interest waiver is more than just a get-in-free card. It's a testament of your potential contributions to the US. Now that we know what a national interest waiver is, who exactly is eligible for one? Well, the eligibility criteria for a national interest waiver isn't set in stone. It's flexible and broad, making it applicable to a wide range of professionals. Typically, applicants should be able to demonstrate exceptional ability or an advanced degree. But here's the important part. You need to show that your proposed endeavor has substantial merit and national importance. That might sound intimidating, but remember, this isn't limited to scientists or researchers. Entrepreneurs, business professionals, or even artists can qualify if they can show that their work benefits the United States. It's not strictly about your qualifications on paper. It's about your potential impact. You might be a software developer with a revolutionary idea, or a chef bringing a unique culinary skill. As long as you can demonstrate that your work is of national interest, you could be eligible. Eligibility for a national interest waiver is not as restrictive as you might think. It's all about your potential impact. You're probably wondering, how do I apply for a national interest waiver? Well, let's dive right in. First off, you'll need to file Form 1140, the Petition for Alien Worker. This form not only establishes your eligibility for the waiver, but also kickstarts the application process. Now, it's crucial that you accompany this form with compelling evidence showcasing your work's significance to the United States. This could include letters of recommendation, publications, awards, and so on. Next, you'll need to demonstrate that it would be beneficial for the United States to waive the job offer requirement. This means proving that your contribution outweighs the nation's interest in protecting its labor market. Remember, a well-prepared case is your best bet at securing a waiver. It might be helpful to engage an experienced immigration attorney to guide you through this process. While the process may seem daunting, with diligent preparation, it's entirely manageable. After applying, how long does it take to get a national interest waiver? That's a question that's on many minds. The typical timeline from application to decision averages around 6 months to a year. However, this is a general estimate and the exact duration can vary significantly. Why is that, you may wonder? Well, numerous factors come into play. Processing times can be influenced by the complexity of your case, the completeness of your application, and the workload of the immigration office handling your case. Some cases may be expedited, while others may require additional review, thus extending the timeline. Remember, each case is unique and timelines can change based on individual circumstances and changes in immigration policy. It's always a good idea to consult with an immigration attorney to help navigate these complexities. Patience is crucial. The timeline can vary, but the wait is worth the potential benefits. Can you continue working while your national interest waiver is pending? Good question. Many people find themselves asking this, and the answer is yes. As an applicant, you're allowed to work during the processing period. However, the type of work you can do depends largely on your current immigration status. If you're on a work visa, for example, an H-1B or L-1, you can continue in the job described in your visa. If you're on a student visa, you can work within the restrictions of that visa. It's important to note that you can't start the work that the National Interest Waiver is for until it's approved. So, if you're applying for a waiver to start a new business, you can't officially launch that business until the waiver comes through. But rest assured, you can continue your current employment. So while the wheels of bureaucracy turn, life and work goes on. And finally, what happens if your national interest waiver is denied? A question that can cause some angst, but don't worry, let's talk about your options. First, it's important not to panic. A denial doesn't mean a dead end, it's more like a detour. You have the right to appeal the decision. This means you can request a review of the denial, providing additional evidence or clarifications to strengthen your case. An appeal must be filed within 30 days of the denial notice, so it's crucial to act swiftly. Alternatively, you can also consider reapplying. Yes, you heard it right. There's no rule against submitting a new application, especially if your circumstances have significantly changed or improved. Remember, each case is unique, and sometimes a denial might just mean that the evidence provided wasn't compelling enough. So, review your application, get professional advice, and give it another shot. A denial is not the end of the road. There are still options available to you. Following a denial, you might feel overwhelmed and unsure of the next steps. That's where the Shaw Pirelli Law Group can step in. You might be wondering, how can the Shaw Pirelli Law Group help me with my national interest waiver? Well, let's break it down. Shaw Pirelli Law Group houses a team of seasoned immigration attorneys who are well-versed in the ins and outs of the national interest waiver process. They can guide you through the complex labyrinth of applying for a waiver, ensuring you understand each step of the process. More importantly, their expertise lies in helping you prepare a compelling case. They can assist you in gathering substantial evidence and presenting it effectively to increase your chances of success. Remember, a well-structured case can significantly improve your prospects, and having a professional by your side can make all the difference. So, don't navigate these rough waters alone. For more information, visit their website at pirellilaw.com. They're ready to help you embark on your immigration journey with confidence and peace of mind.